story contains complex conflicts and sensitive situations. Viewer discretion is advised.
The hives started at my collarbone before the appetizers arrived. We were seated at a long table near the windows of a restaurant in uptown Charlotte a Wednesday night in late March, the kind of place companies choose when they want a contract to feel inevitable. I had put on a navy dress from my closet less than an hour earlier. I had washed it the night before, hung it to dry, and checked it for lint the way I always do. 10 minutes into the introductions, my skin tightened. Heat climbed up my neck. I excused myself before anyone could ask why my hands were shaking. In the restroom mirror, red welts were spreading across my throat and down both arms. I knew that pattern. I had not seen it in years, but I knew it. There is one preservative I have avoided since I was 19 after an ER visit that ended with a warning written in my chart in bold letters. I read labels. I bring my own detergent when I travel. I do not take chances. I had taken none that night. My name is Hannah Pierce. I am 32, a senior account manager for a regional logistics firm based in Charlotte. The dinner was not social. It was the final step before signing a service agreement with a client we had been courting for 3 months. My director, Mark Ellison, was seated 2 chairs away when I stood up. He looked at me confused as I said I needed air. By the time I reached the hallway outside the dining room, my forearms were mottled and burning. One of my colleagues followed me. He asked if I needed an ambulance. I told him no, but my voice did not sound steady. We called a rideshare instead of waiting for EMS. The urgent care clinic on South Tryon stays open until 9 on weeknights. It was just after 7:30. I remember checking the time because part of me was still thinking about the contract on the table I had just left behind. At the clinic, a nurse took my vitals and asked about known allergies. I gave her the name of the preservative without hesitating. It has a long chemical name, one I memorized years ago because I had to. She noted it, then asked what I had eaten. Nothing unusual. Grilled fish, plain vegetables, water. She asked about new soaps, detergents, lotions. I told her I had worn a dress from my own closet, washed at home, no new products that I knew of. While we waited for the physician assistant, I tried to reconstruct the last 24 hours. I had worked late the night before. When I got home, I moved a load of laundry into the dryer and hung the navy dress on a padded hanger in my bedroom. My younger sister Lila was in the living room watching television when I passed through. She has been staying with me for 2 months since she lost her job in Asheville and decided Charlotte offered more options. The week of the dinner, I had mentioned the commission the contract would bring, not to boast just relief. It would cover the last of my student loans. Lila had gone quiet at the table. She said she was still waiting to hear back from 3 job applications. She had asked earlier that evening what I was wearing to the dinner. I told her the navy dress. She said it made me look corporate, but not cold. I remember that because I almost changed my mind after she said it. The physician assistant examined the rash and ordered medication to reduce the reaction. She did not look alarmed, but she did not dismiss it either. She asked again if I was certain about my known allergen. I was. As I sat there with a paper bracelet around my wrist, I realized something simple and unsettling. I had not introduced that substance into my life in years. It did not appear in my detergent. It was not in my shampoo. It was not in my home. If it was on my skin, it had come from somewhere specific. Back at the restaurant, the contract discussion was continuing without me. Mark texted to ask if I was all right. I told him I had a reaction and would follow up in the morning. He responded with a brief acknowledgement. No anger, no reassurance, just business. By the time I left the clinic with a prescription and discharge papers, the swelling had slowed, but the question had not. I had washed that dress myself. I had hung it in my own closet. I had taken it off the hanger less than an hour before sitting down at that table. And yet my skin had reacted as if I had ignored every precaution I have lived by for more than a decade. Somewhere between my laundry room and that dinner table, something had changed. I did not yet know what that something was, but I knew it was not random. By Thursday morning, the swelling had gone down, but the discharge papers were still on my kitchen counter. I had taken the day off work. Not because anyone suggested it, but because I needed to understand what had happened before I walked back into the office and tried to explain it as an unfortunate interruption. The clinic had uploaded my visit summary to their patient portal overnight. I logged in just after 8 while the apartment was quiet. The report was clinical and direct. Acute allergic dermatitis. Trigger confirmed exposure to methylisothiazolinone. Known prior sensitivity documented. Recommendation, strict avoidance, and environmental review. There was no room for interpretation in that language. The physician assistant had added a note stating that given my documented history, incidental exposure was unlikely if established avoidance practices were maintained. I read that sentence twice. Established avoidance practices were maintained. That was the closest a medical document comes to saying, this should not have happened. I printed the report and placed it in a folder with the prescription receipt. I have kept a copy of my allergy documentation for years, ever since my hospitalization at 19. It includes the ER summary, the follow-up visit with an allergist, and the written instruction to avoid products containing that preservative. I added the new report to that file. Lila came into the kitchen around 9, still in sleep clothes, scrolling through her phone. She asked if I was feeling better. I told her the swelling had subsided. She glanced at the papers on the counter but did not pick them up. I did not hand them to her. I checked the products under the sink, then the ones in the bathroom. Detergent, softener, soap, shampoo. I read every label. The ingredient list had not changed. The physician assistant had asked me to review any recent product introductions in the home. I stood in the doorway of my bedroom and looked at my closet from a distance, as if it belonged to someone else. I had done a load of laundry Tuesday night. I remembered transferring the navy dress from the dryer to a hanger. I do not use scented boosters. I do not experiment with new sprays. I have built routines around that allergy because I learned the hard way that a mistake can escalate quickly. There are only 2 people with regular access to my bedroom, me and Lila. The report did not accuse anyone. It did not speculate. It did something more unsettling. It narrowed the possibilities. Later that afternoon, an email from Mark appeared in my inbox. The client had decided to pause finalizing the contract until they could reschedule a proper closing meeting. He wrote that he understood medical emergencies happen, but timing matters in business. The subtext was clear enough. I forwarded the urgent care summary to HR, attaching a short explanation that I had experienced a documented allergic reaction and had sought immediate treatment. I did not mention Lila. I did not mention my suspicions. I stayed with facts. Within an hour, HR classified the incident as a documented medical emergency. The dinner was no longer an unexplained disruption. It was on record. No disciplinary review, no attendance flag. That small confirmation steadied me, but it did not answer the larger question. By early evening, I had reviewed every cleaning and personal care product in the apartment. Nothing contained the preservative. Nothing had changed. The medical report had given the reaction a name and a cause. It had also made one thing unavoidable. The source was not random and it was not theoretical. If that substance touched my skin Wednesday night, it had entered my environment deliberately or through a specific action. I stood in front of my closet again, this time closer, and looked at the row of dresses. Only one of them had put me in urgent care. I waited until Saturday morning to go through my closet in a way that felt deliberate instead of reactive. Lila had gone out early to meet a friend for coffee. I heard the door close and her car start before I walked into my bedroom with a notepad in my hand. I did not want a confrontation. I wanted a timeline. I began with the dress. It hung where I had left it, sealed inside a protective bag. The closet, however, was slightly off hangers, out of order, one padded hanger missing. On my dresser, the small travel fabric spray sat uncapped and empty. Someone had handled items in my room. I stepped into the hallway and glanced toward the guest room Lila had been using. Her door was open. The bed was unmade clothes draped over a chair. I did not enter. I was not looking for evidence in her space. I was accounting for mine. Back in my room, I opened the top drawer of my nightstand. I keep copies of important documents there: insurance cards, allergy documentation, my driver's license, renewal notice. The stack was slightly angled, as if someone had lifted it and replaced it without aligning the edges. Lila has known about my allergies since we were teenagers. She was the one who drove with our mother to the hospital when I reacted the first time. She saw the swelling. She heard the instructions from the allergist. It was never a secret. I moved to the laundry basket in the corner. It was empty. I had done the last load Tuesday night. I checked the washer and dryer in the hallway closet. The lint trap was clean the way I always leave it. There was no dramatic discovery waiting for me, no spilled chemical, no open container. What I had instead were small inconsistencies layered on top of a medical report that left little room for coincidence. At noon, Lila returned. I was at the dining table with my laptop open, reviewing the ingredient list from the urgent care summary and comparing it to common household products. She set her keys down and asked if I was working. I told her I was trying to trace exposure. She said that sounded intense. I asked her evenly if she had gone into my closet Tuesday night after I did laundry. She paused for a fraction of a second before answering that she might have moved a hanger while looking for a scarf she thought was hers. It was not a confession. It was not a denial. It was access. I wrote down the date and time as best I could reconstruct it Tuesday around 9:30 p.m. after I transferred the laundry. Lila awake in the living room, me in and out of the bedroom. The closet was no longer just a storage space. It had become the only physical link between a documented allergen and my skin. And for the first time since Wednesday night, the question shifted from what happened to who had the opportunity to make it happen. On Sunday afternoon, I decided to stop circling the question and check the one place I had avoided since Wednesday. The laundry closet sits off the hallway between the kitchen and the guest room. It is narrow with wire shelving above the washer and dryer. I keep my detergent on the top shelf and nothing else. I do not rotate brands. I do not experiment. That afternoon, there was something new. A slim plastic bottle with a pastel label stood beside my detergent. I had not bought it. The brand name meant nothing to me, but the words Fabric Refresh were printed in large letters across the front. The cap was slightly sticky, as if it had been handled recently. I took the bottle down and turned it over. The ingredient list was printed in fine gray text. I scanned it once, then again, more slowly. Methylisothiazolinone appeared in the middle of the paragraph, the same chemical name that had been highlighted in my medical file for over a decade was listed plainly on a product sitting in my home. I set the bottle on the kitchen counter and pulled out my phone. I took clear photos of the front label, the ingredient list, and the barcode. Then I searched the brand online. The product description confirmed what the label already told me, a preservative blend designed to prevent bacterial growth in liquid sprays. There was no ambiguity about what it contained. I opened my email and typed the product name into the search bar. An order confirmation appeared under Lila's name from 3 days earlier, time-stamped Monday evening. The shipping address was mine. The receipt showed 1 bottle standard delivery charged to her debit card. I did not forward the email. I did not confront her. Instead, I saved a PDF copy of the receipt and placed it in the same digital folder where I had stored the urgent care report. I emailed the file to myself from a secondary account I use for personal records. The bottle itself I left on the counter exactly where I had placed it. When Lila came home later that evening, she walked past it without comment. She went to the refrigerator, poured herself water, and scrolled through her phone. I asked evenly whether she had ordered a new laundry product this week. She said she had been trying to freshen up some of her clothes and thought a spray would help. She said she did not think it would matter if it was used lightly. I asked if she had checked the ingredient list. She shrugged and said she does not read labels the way I do. She had said something similar before, that I built my life around restrictions, that I made small things feel dramatic. When she moved in, she joked that living with me was like living in a laboratory. Everything labeled, everything controlled. I had laughed then, but she had not. Growing up, I was the cautious one. She was the improviser. My limits looked like judgment to her. Her risks looked like recklessness to me. We had learned to live around that difference. Living inside it was new. The exchange was brief. There was no raised voice. But something shifted in the air between us. This was no longer a question of access alone. There was a purchase. There was a product. There was a documented allergen. There was a reaction. And there was a timeline that connected all 4. I picked up the bottle again after she went to her room and sealed it inside a clear storage bag. I wrote the date on a piece of tape and attached it to the plastic. The risk in my life had taken physical form. For the first time since Wednesday, I was not asking whether something had changed. I was looking at it. I drafted the notice on Monday evening after work, sitting at the dining table where Lila and I used to share takeout without thinking about boundaries. North Carolina does not require a formal lease to establish residency. Lila had been staying with me for 2 months, receiving mail at my address, contributing occasionally to groceries, but not listed on the lease. That placed her in the category of a month-to-month occupant. I confirmed the language through the Mecklenburg County Court website before I wrote anything. The document was simple. 30 days to vacate, date specified, address listed, signed and dated by me. I did not print it immediately. First, I asked Lila to sit down. I laid the urgent care report on the table next to the printed receipt for the fabric spray. I placed the sealed plastic bag containing the bottle between us. I did not raise my voice. I did not ask rhetorical questions. I asked her to look at the ingredient list. She said she had already told me she did not think it would matter. She said she had used only a small amount. She said she did not think my allergy was as serious as I made it sound. She admitted she had sprayed the dress lightly after it came out of the dryer. Just to freshen it, she said. She had not told me because she did not think it was necessary. I reminded her that my allergy had put me in an emergency room once before. I reminded her that she had been there. She shifted the conversation toward my job, saying that if I had not made such a big deal at the dinner, maybe the contract would still be intact. The implication landed cleanly. The problem was my reaction, not her choice. That was the moment something settled inside me. I stood up, walked to the printer and pressed print. The pages slid out one by one. I handed her the notice and told her she had 30 days to make other arrangements. She stared at the document longer than she had looked at the ingredient list. She said I was overreacting. She said families work things out privately. She said she had nowhere else to go. I told her I could not share a home with someone who introduced a substance into my environment that could close my airway. The sentence sounded clinical, but it was the truth. She asked if I was threatening her. I said I was setting terms. There was no shouting, no broken plates, just a quiet reordering of the room. She folded the notice once and placed it on the table. Then she went to the guest room and closed the door. I remained in the kitchen, aware that the air between us had changed in a way that would not revert. Up until that point, I had been trying to understand what happened. Now I was acting on it. The 30-day clock began that night. By Tuesday morning, the apartment felt smaller, as if the 30-day notice had reduced the square footage. I returned to the office knowing the contract was no longer secure. The client had asked to reassess timing, which in our industry often means they are considering alternatives. Mark scheduled a meeting for 10 a.m. with me and a representative from HR. The meeting took place in a glass-walled conference room overlooking South Tryon. HR introduced herself as Denise Harper, Employee Relations. She had a folder in front of her and my name was written across the tab. Mark summarized what had happened from a business perspective. A senior account manager left a closing dinner unexpectedly. The client paused execution. Revenue projections shifted. Then Denise asked me to walk through the medical event. I provided the urgent care summary I had already emailed. I explained that I experienced an acute allergic reaction to a documented preservative and sought immediate treatment. I stated that I had not consumed any unusual food and that the reaction had been confirmed by the clinic. Denise asked whether the allergen was present in the restaurant environment to my knowledge. I said no. I said the only new variable in the prior 24 hours was a fabric treatment introduced in my home. I did not assign blame. I described sequence. Denise took notes. She asked whether the condition posed an ongoing risk to my ability to meet clients. I told her the allergen is avoidable when I control my environment and that I have managed it without incident for years. I also stated that I would provide any documentation required to confirm fitness for duty. The conversation lasted 40 minutes. By the end of the meeting, the incident was formally recorded under company medical policy. There would be no disciplinary action and no notation of misconduct. The client's delay, however, meant the commission tied to that contract would not be paid in this quarter. Lila knew what that number meant. It was more than she had earned in the last 6 months. She had said once that stability must be nice. That was a number I could quantify. Back at my desk, I reviewed the projected bonus spreadsheet. The difference between a closed contract and a postponed one was several $1,000s. Not catastrophic, but real. Around noon, my phone buzzed with a text from my mother. Lila had called her. The message was brief: "You're pushing her out over a mistake." I did not respond immediately. Later that afternoon, Lila sent an email copying both our parents. She wrote that I had misinterpreted her attempt to help freshen my clothes and that eviction was extreme. She mentioned my job, suggesting that stress might be clouding my judgment. The email did not deny purchasing the spray. It reframed it. I read it twice, then archived it with the medical report and receipt. Her version was preserved before it could evolve. I did not reply to the group thread. Instead, I sent a short message to Mark confirming I would attend the rescheduled client meeting the following week and that my medical issue was under control. That same week, I confirmed 2 things in writing. HR classified the dinner as a documented medical emergency, and the property manager confirmed that once Lila vacated, the locks could be rekeyed at my request. Both institutions recorded the situation as procedural, not personal. That mattered. Action, not argument. I confirmed with the property manager that once Lila vacated, the locks could be rekeyed at my request. The exit was no longer theoretical. It had a date. As I rode the elevator back up, I understood that the consequences of that Wednesday night had extended beyond a rash. There was a financial impact at work. There was family pressure. There was an official notice counting down in my own home. None of it had reversed anything yet, but the perimeter around my life was beginning to take shape. 2 weeks into the 30-day period, a certified envelope arrived addressed to me. I signed for it in the lobby. The return address listed a local attorney's office in Charlotte. I recognized neither the firm name nor the attorney. Inside was a formal letter stating that Lila disputed the validity of the termination notice. The document argued that she had contributed financially to the household and therefore qualified as a tenant with additional protections. It requested that I rescind the notice and proposed mediation before any further action. The letter was measured in tone. It did not accuse me of fabrication. It reframed the situation as a housing disagreement rather than a safety issue. It also implied that if I proceeded without good faith negotiation, she might seek legal remedy for wrongful eviction. I read the letter twice at my desk that afternoon. North Carolina law is clear about month-to-month occupancy when there is no written lease and only partial contribution. Still, legal process requires procedure, not assumption. I did not respond directly. Instead, I scheduled a consultation with a housing attorney recommended through the North Carolina Bar Referral Service. The appointment was set for Thursday afternoon. When I met with him, I brought copies of everything: the notice proof of delivery, the urgent care report, the product receipt, and the email thread. He reviewed the documents without interruption. He confirmed the notice met North Carolina requirements for terminating a month-to-month occupancy. If she refused to leave after the deadline, the next step would be a court filing. Not another conversation, a hearing. Procedure would replace discussion, and once it entered the system, it would move on a timeline that did not depend on either of us. He advised me not to change the locks before the deadline and not to remove her belongings. He also suggested I communicate only in writing going forward. When I returned home that evening, Lila was in the living room on a video call. She ended it quickly when she saw me. She told me she had just wanted legal clarity. She said she felt blindsided. I told her the notice stood. The conversation did not escalate into shouting. Instead, it narrowed. She began documenting small grievances, temperature settings, noise, shared groceries. She sent emails summarizing minor disagreements, copying our parents again. The tone shifted from emotional appeal to recorded narrative. I responded only to essential logistical matters and kept each reply brief. At work, Mark informed me that the client had asked for additional assurances regarding continuity. He did not reference my medical event directly, but he asked if there was anything personal that might disrupt upcoming meetings. I told him there was not. The tension was no longer contained within my apartment. There was a legal letter in play. There was the possibility of a court date. There was a client watching for stability. The situation had moved beyond a family disagreement. It had entered record. The 30th day fell on a Friday. Lila had not packed. Her mail was still arriving in the metal cluster box downstairs. Her shoes were still lined up by the door. The guest room door remained closed most of the day, but nothing in the apartment suggested preparation for departure. On the 30th day, I filed for summary ejectment. By Monday, a sheriff's deputy stood in our hallway and handed Lila the summons. The matter was no longer internal. It had been formally served. She stood in the hallway, holding the papers, her expression steady. She said she could not believe I had taken it this far. I told her the deadline had passed. That evening, she sent another email to our parents attaching a photo of the summons. This time, the tone shifted again. She described me as unstable, suggested that my medical anxieties were escalating into legal aggression. She implied that my employer might not appreciate public court records tied to my name. It was the first time she connected the housing dispute directly to my professional standing. I did not respond to the family thread. I forwarded the summons to HR the same day. The dispute was documented internally before it could be reframed as instability. I confirmed I would use personal time for the hearing and return to work. Denise replied within an hour, acknowledging receipt and reiterating that the company did not involve itself in private civil disputes unless performance was affected. The boundary was clear. On Wednesday, my attorney confirmed the hearing would be straightforward. If the notice and timeline held, the decision would turn on documentation, not argument. That night, I moved important documents and valuables into a locked file box and stored it in my car trunk, not out of fear of theft, but to remove variables. The situation had narrowed to a single room in a courthouse and a date on the calendar. The conflict was no longer private interpretation. It was scheduled. The hearing was scheduled for 9 a.m. on Thursday in small claims court. I arrived 20 minutes early carrying a slim folder with copies of the notice proof of service, my lease, and the receipt for the filing fee. The courtroom was smaller than I expected. Wooden benches, a single table for each side. A magistrate seated behind a raised desk rather than a full bench. Lila arrived 5 minutes before the docket was called. She was dressed carefully, hair pulled back, a thin stack of papers in her hand. She did not look at me. When our case number was announced, we stepped forward. The magistrate asked me first to confirm that I was the leaseholder and that I had provided a 30-day written notice to terminate a month-to-month occupancy. I handed over copies. He reviewed the dates. He asked Lila whether she disputed receiving notice. She said she received it but believed she had established tenancy through financial contribution. She referenced grocery receipts and partial utility payments. She also mentioned that I had personal sensitivities that escalated the situation. The magistrate redirected her to the housing issue. He asked whether there was a written lease in her name. There was not. He asked whether she had paid rent directly to the landlord. She had not. He asked me whether the notice period had elapsed before filing. I confirmed the timeline. The exchange lasted less than 15 minutes. The magistrate ruled that proper notice had been given and entered judgment for possession in my favor. Lila had 10 days to appeal. If she did not, the clerk could issue a writ of possession upon request. There was no commentary on motives, no analysis of family dynamics, only procedure. Outside the courtroom, Lila stood very still for a moment, then told me I was humiliating her. I told her the judgment spoke for itself. She said she would consider an appeal. I said that was her right. By late afternoon, I received confirmation through the online case portal that judgment had been entered. The case status changed from pending to decided. At work the next day, Mark informed me that the client had signed the contract after the rescheduled meeting. The commission would be reflected in the next quarter's numbers. It did not feel like triumph. It felt like stabilization. At home, Lila began packing in earnest for the first time. Boxes appeared in the hallway. The shoes by the door were reduced by half. The court had not solved everything, but it had shifted the center of authority out of our living room and into a record that did not bend. For the first time since the rash spread across my neck, the outcome was no longer theoretical. It had a date, a signature, and a deadline. Lila did not file an appeal. The deadline passed quietly. The option for enforcement existed, documented and available. I did not need to use it. 3 days later, Lila loaded the last of her boxes into a rented sedan. She did not say goodbye. She left her key on the kitchen counter next to the folded copy of the original notice. By the end of that afternoon, the guest room was empty. The following morning, the locks were rekeyed. When the new keys settled into my palm, the apartment felt structurally different. At work, the rescheduled contract moved forward without incident. The commission posted in the next quarterly report exactly as projected. The medical claim was processed through insurance. The housing case closed without appeal. The systems that had been set in motion resolved themselves one by one. One Saturday morning, I went through the apartment with a trash bag and removed every remaining product containing methylisothiazolinone, even those that were technically Lila's. I wiped down the shelves in the laundry closet and left only the detergent I have used for years. The space felt quiet in a way it had not for months. My parents called twice that week. I let the calls go to voicemail. The messages were no longer accusatory, only tired. I saved them without replying. I did not block them. I did not resume weekly dinners either. I changed one more thing. I moved the navy dress to the back of the closet, not out of fear, but because it no longer needed to anchor the front. I bought a new dress for the next client meeting. I read the label before cutting it off. The next time I sat across from a client, my skin was clear. The contract discussion stayed on track. No one referenced the previous interruption. The difference was not dramatic. It was structural. My home was secure. My job was intact. The record was closed. The lesson did not arrive as a speech. It arrived as a lock that turned smoothly, a calendar without court dates, and a closet that no longer held questions. If you have ever had to draw a line in your own home to protect your health or your work, you know the cost is rarely just emotional. It is logistical, legal, and sometimes permanent. For me, the boundary held, and that was enough.